My name is Marck Joseph, and I'm a South Florida family law attorney. And these are 5 things you should know about mediation. So, you're in the middle of your family case, and the judge refers you to mediation. What is that? Well, mediation is the opportunity that you have to resolve your case before going before the judge. When you're in mediation, a neutral third party, who's not a judge, attempts to help you and the other party resolve your issues and enter into a settlement agreement. This is a voluntary process. Although the judge orders you to mediation, you are not required to settle at mediation. It's strongly encouraged. However, if you feel like you want to go before the judge, you're entitled to. And when you're there, you can just agree to impasse. What an impasse is the decision to just shut down mediation and not come to an agreement. Mediations are confidential. What this means is what is discussed during the mediation cannot be disclosed or spoken about to anybody else except the parties that were in the mediation. This is very important, especially if you hear something during the mediation that you want to use in court, or the party says something or is unreasonable during the mediation. You cannot tell anyone, especially the judge. The mediation process is non-adversarial in nature. What this means is it's not a place where you should be arguing or trying to make legal points, because essentially you're there to try to resolve the issue. Some attorneys or some parties may take the position of being argumentative, citing legal conclusions and stuff like that. However, the best results I've seen in mediation are when both parties come down, try to focus on resolving the issue other than attacking the other party. You don't have to wait for the court to refer you to mediation before going to mediation. Sometimes parties, instead of trying to go through the court process, will decide to go to a mediator before even filing. That way, they can attempt to resolve the issues before it becomes a messy litigation situation. And if you're able to come to a conclusion and resolve your issues, you can actually just file jointly for whatever issue, whether it be divorce, paternity action, or child support. And all you do is essentially go to court with the agreement that you sign and go through the process, and you get your final judgment. It minimizes the stress, hassle, and cost of going through your situation as an alternative to litigation. That being said, mediation is a much better alternative to trial. Although we as people want to have our voices heard before the judge, the process of getting before the judge at a final hearing can be time-consuming, stressful, and incredibly expensive. Going to a mediator or doing mediation will assist you in trying to resolve the issues without incurring any of the cost and mental stress. Now, these are only 5 things. Mediation and the family court process is much more complex than that. So if you have any additional questions regarding those things, feel free to contact my office and we can have a consultation. And if you enjoyed this video, feel free to look at my other videos. Like and subscribe as well. Thank you for watching.